Hey everybody, how's it going? Welcome back to Copper Jacket TV. So I gotta be honest, I don't think I've ever seen California receive such a massive smackdown at the Ninth Circuit Court of Appeals. You guys know how the Ninth Circuit is. They almost always side with the state of California. Well, just this morning we had oral arguments in Nguyen v. Bonta, which is a case that challenges California's 1 in 30 law. Now, there were 3 judges on the panel. We had one judge that was appointed by Obama. It's the gentleman that you'll see here in just a second sitting in the center. And even he seemed to be on our side when it comes to this topic. So it was absolutely fascinating. We're going to watch this together, give you guys a little bit of commentary on it. And you have to see what the state's argument is, because the state doesn't really have an argument. Through this entire thing, I'm not sure that I heard one single argument from the state. There's no relevant historical analogs. They can't really back up the claims. I mean, it was just a massive blowout. So let's check it out together. You guys are going to want to see this. Okay, so the attorney that you're looking at right there on the bottom right, that's the attorney for the state of California representing Bonta and the DOJ. He's the first one to talk. The gentleman in the center right there, he is the Obama-appointed judge, and you'll see some of the stuff he has to say. This guy cannot talk. He's not a very good speaker.
You may proceed.
Good morning. May it please the court. Jerry Yen for the California Attorney General. I'd like to reserve 3 minutes for rebuttal.
Yeah, you're going to need
This
that.
case presents a facial Second Amendment challenge to a commercial regulation on the sale of firearms, which requires an individual to wait 30 days after they have purchased the firearm before they can purchase another one. The regulation seeks to disrupt the illegal firearms trade and make it more difficult for straw purchasers and prohibited persons from acquiring firearms.
When the state decided to
Immediately
pursue this policy,
interrupted.
was there any information or evidence in which they determined that a delay of 30 days would actually disrupt this practice of straw purchasers?
There were other states had passed similar regulations, and there were also some studies that showed that a 1 in 30 kind of regulation would disrupt the illegal firearms trade.
Because I was wondering whether the source of the 30
Other
days,
states do it.
Is this an arbitrary number? Would you have the same effect if it were every 10 days, if it were 15 days, if it were 45 days? How did the state settle on 30? Just following other statutes?
Well, I think that was a consideration for the legislature, but I think what we're looking at here is whether or not 30 days is within the scope of the Second Amendment. And
0 minutes is within scope of the Second Amendment.
That's something that is presumptively protected. And in this case, the law doesn't limit the number of firearms that an individual can own. It just really controls the pace at which the firearms can be accumulated.
Do you, and I agree with you, the way you put the question is correct. I was just curious about how the state had settled on that time period, but do you believe that the Bruin analysis applies? In other words, that this regulation falls within the plain text of the Second Amendment, and then we look to a historical analog?
That's correct. The text and history standard that the Supreme Court has set out would apply here, and it is plaintiff's burden to show that it is, at the first step, that it is presumptively protected by the Second Amendment. And in this case, they haven't done so because we
haven't proven that acquiring arms is protected by the Second Amendment. That's what California believes.
Purely based on the text of the Second Amendment, it doesn't mention anything about purchasing. It's keeping and bearing, and the Supreme Court has stated that keeping and bearing refers to possessing and carrying.
But you can't
we've addressed
possess.
That issue in 2 cases.
You can't possess if you can't acquire, so it is absolutely protected.
And described acquisition as an ancillary right. So how does that affect the analysis?
So that's correct, Your Honor. It is an ancillary right, and as an ancillary right, as B&L Productions states, there is some protection for ancillary rights, but it's a plaintiff's burden to provide evidence that any regulation that touches on ancillary rights would have a meaningful constraint or impair an individual from being able to exercise their core Second Amendment rights of possessing a firearm for self-defense. And in this case, we have plaintiffs that already have firearms, and they can't purchase a firearm and just have to wait 30 days before purchasing another one. So they are exercising their core Second Amendment rights.
We
There's
let
no
you have a
dispute
little
about
bit,
that.
Do I
so that's
understand the
enough.
state's argument to be that the Second Amendment guarantees the right to bear an arm, that it could be just one arm and then your right is satisfied?
Oh, it's
Well,
so good.
Admittedly, Your Honor, the term arms is plural. But what we have in this case are plaintiffs who already currently own arms, and so they can purchase another one. So they are exercising that Second Amendment right of possessing multiple arms. And so this
So I guess I want to make sure I understand your answer. Is your answer that no, the state of California's position is not that the Second Amendment is satisfied so long as you can possess one firearm?
So the Second Amendment right is encompassed in the fact that the arms is plural. So
We got that.
other courts have said that that means that you can possess more than one firearm, but that doesn't mean that you can acquire more than one firearm at a time. And so that's what we have in this case, is whether or not you can purchase multiple firearms within a 30-day period. You just have to wait 30 days.
I mean,
before-
I get the temporal argument, and I understand why you make it. What I'm trying to figure out is, if you had somebody who wanted to buy a firearm, wanted to buy two firearms for whatever, maybe they have two homes and they want a weapon in both homes for self-defense reasons, which would be core Second Amendment territory,
Yes.
and they don't have any already, there is a period of time that the state has said you don't get to do that.
Yeah,
And
that's right.
how do you balance that with, if it's true that the Second Amendment covers the right to bear more than one firearm, how can you, how does that temporal limitation square with the Second Amendment?
It doesn't. Answer,
Well,
it
this
doesn't.
case is a facial Second Amendment challenge. So we know from Rahimi that the Supreme Court says that when you're faced with a Second Amendment challenge, we look at situations where it is constitutional and not at hypothetical situations where,
Well, that's fine, but I want you to address my question.
with respect to that particular individual that doesn't have any firearms currently.
Correct.
Okay. So if a individual does not currently have any firearms, there are other avenues to obtain firearms.
No.
For example,
There's not.
if
California locked down all of those other options.
there are regulations that allow for individuals to borrow firearms from other individuals. I mean, there's definitely certain regulations related to that, but
You
there
still have to
are
go through a
other
10-day
options
wait.
to do that. And then if you have one and you need one for self-defense, there are also exceptions to the law that's being challenged, including if for example, a firearm's lost, or if you want to exchange a firearm.
That doesn't really address the situation that I presented to you, though.
No.
I mean, and the
there's
other
no
reason
way
that
to
I'm thinking
address
about
it.
this is California has chosen a 30-day window of time to sort of space people out in acquiring firearms. But what if California had said a year?
So Bruin does give us some guideposts on waiting periods. And Bruin says that if it's a lengthy waiting period, and it talks about exorbitant fees, or if a challenged regulation is put towards abusive ends, that would definitely get closer to something that is presumptively protected. So if we're talking about something that's a year, that would get obviously closer to the lengthy wait times.
Closer. Notice he says closer.
Bruin suggests would not be
He's not saying
would
that a
be
year would be
presumptively
excessive.
protected, would implicate
He's
the
saying
Second
that's
Amendment.
getting closer
But
to
that's not what we
excessive.
have here. We have a
California would be
30-day
good banning them
period,
forever.
so it's really a really short waiting period from after you have a firearm to purchasing the next firearm.
But getting back to the question that Judge Forrest asked, I'll change the hypothetical slightly. If I own a small liquor store and a gang is saying, we're going to, if you don't pay us protection, we're going to get you here, or we're going to get you at your house, but we're going to get you. So I say, but boy, I better have a gun in my store. I need to have a gun in my house. And I don't have any firearms. Under the state of California's rule, I could buy a gun to protect my store or my house, but I couldn't buy one for each, correct? And I'd have to wait 30 days.
That's right, Your Honor. You would have to wait 30 days from when you purchased your first firearm.
This
to
is the
getting-
Obama
So
point
with
that
that
I was
understanding, if the core right the Second Amendment is trying to protect is self-defense, then it seems to me that the law here is impeding that core right. There are other ways you can attack straw purchasing and bundling guns. I mean, I understand the state's interest in that, but in the hypothetical that Judge Forrest raised, I mean, that seems to be core Bruin conduct, the ability to defend yourself with a firearm either in your home or your place of work. How do we get around that in this case, unless you can point us to a historical analog?
And so we don't. So if the court assumes that it is presumptively protected, and that the plaintiffs haven't rebutted the presumption of lawfulness as a commercial regulation, then the state has provided a robust historical record that supports the tradition of commercial regulations that regulate the sale of firearms, and in order to prevent unauthorized and dangerous individuals from obtaining them. And
Except for the California law that we're talking about today isn't limited to unauthorized or dangerous individuals. It's every citizen of California or every person who tries to buy a gun in California. So you have some historical analogs for sure about identifying certain groups of people and assessing their dangerousness or their lawfulness, or their whether they're good citizens and so on. But I'm looking through the record, and I'm not seeing a whole lot of support for the idea that you can sort of space out somebody's exercise of their right, or that you can, or historical analog saying you can only buy one gun at a time.
Well, I guess maybe the better way to think about it, or the way that I think about it, is it's really just a waiting period. So you're waiting 30 days. You already have a gun that you can use for to exercise the core right of self-defense, and then you wait another 30 days.
But not under the hypotheticals that Judge Owens and Judge Forrest presented, because they're talking about a first-time purchaser. And as I understood your answer, the regulation would prevent a first-time purchaser from buying more than one gun at their first purchase. So they don't have a gun at all, but they can't have two to begin with. They have to get one, wait a month, and they could get another one.
That's right, Your Honor. And again, we're really faced with a facial challenge where it's the plaintiff's burden to show that in no set of circumstances would it be constitutional. And we're talking about plaintiffs who already have firearms. And so since they already have firearms, they are exercising that course.
So, but even under the analysis that you posited, that this isn't within the plain text of the Second Amendment, it's not keep and bear arms, it's the ancillary right of acquisition. Then B&L and Tejera talk about whether that regulation meaningfully constrains the ancillary right to acquire a firearm. So these hypotheticals that have been presented seem to suggest that if you can't buy two firearms for self-defense, that's a meaningful constraint on your Second Amendment right.
It's a pretty big constraint.
Even if we don't go to the historical analysis, how is this not a meaningful constraint?
Because the right to acquire
it's
has
not
been
a meaningful constraint because in B&L Productions and in Tejera, those they provided some examples where something would be a meaningful constraint. Where, for example, there's a ban in a particular region, that would be a meaningful constraint.
So I agree with you. I think I know where you're going. That those cases were easier, right? Because it was sort of a zoning thing where you could get a gun 600 yards away. Something. It was a different circumstance. Here we're talking about a temporal restriction, which is a little harder to pin down. And if you look at like McRory from the Fifth Circuit, where they said 10 days is okay. That's the waiting period. So if we assume that that's correct, 10 days doesn't meaningful constrain your right to acquire a firearm, but a year does, or 10 years does. Where do we go between? How do we make a limit between 10 days and a year?
10 days is still unconstitutional.
That's a good question, Your Honor. But I think in this case, the court doesn't need to draw a particular line saying, okay, well, well, a year is too long or a year is good enough. What we're faced here is really 30 days. And if we look at 30 days, that is really a short period of time. And other jurisdictions have passed similar laws.
It's a month.
And in fact, in New York City, for example, has a law that you can only purchase one firearm every 90 days. So 30 days is really a short period of time.
So somebody else is even more unconstitutional. So
case has been pending
if
since
they're
2020.
unconstitutional, we get to be
The
unconstitutional.
plaintiffs would have been able to purchase dozens of firearms with that.
Well,
within that
counsel,
period
I mean,
of time.
I'm trying to understand sort of a fundamental premise here. The Supreme Court has said that for Second Amendment cases, we can look by analogy to other rights that citizens have, including First Amendment rights, et cetera. It would be absurd to think that a government could say, you can only buy one book a month because we want to make sure that you really understand the books that you read. Or you can only attend one protest a month because, you know, there are some societal drawbacks to having protests, and so we want to kind of space those out. People would say that's absurd. So if we conclude that you have a right to bear arms, and we conclude that that's not the right to bear an arm, but could be plural, like what is the basis in the law anywhere for the idea that you could say to someone, yes, you have this right, but we're going to control how frequently or how often you get to exercise it?
Well, the historical analogs that we've presented do show that a robust record of commercial regulations that do have the ability to prevent dangerous individuals. Now, if we, just for example, we'll take the intoxication laws. That is a temporary ban, basically.
It's
on
super
someone being
temporary.
able to
Somebody who's
obtain a
intoxicated
firearm.
can't
They
take a
purchase
transfer.
a firearm while they're intoxicated.
He could sober up in a few hours.
Once they are no longer intoxicated, they can purchase a firearm.
But that's going to be presumptively less than 10 days. I mean, it's going to fall with, it would fall within what we would call a waiting period unless they're just, you know, a habitual drunkard, but, you know, they're not going to be drunk for 30 days. Right. So, I mean, it seems that's fleeting and would presumably be a much shorter period of time.
It's not a relevant analog.
Right. So, but I think the analysis here is whether or not it's relevantly similar and whether or not we're addressing issues that weren't of a concern back then during the founding. So in this particular
It's not
case,
relevant because they identified
it doesn't need to
somebody
be identical, right? It doesn't need to
who
be
is not
okay,
allowed to
well,
have a
someone's
transfer
gonna-
at that time.
They're going to
by
see someone that's drunk
means
for
of him
30
being
days, and so then
intoxicated.
that's the limit. The idea is
California's
that
law affects everyone,
supports a
law-abiding
principle
included.
of commercial regulations preventing people from obtaining firearms and that are dangerous or unauthorized. And that's what we have here, is trying to prevent the ultimate transfer of firearms to those that are not authorized to possess or carry them.
Do you want to reserve?
Yes, I see that I am coming up on three minutes. So.
We'll give you 5 for rebuttal.
Okay, thank you, Your
All
Honor.
right, thank you.
Yeah, that's who California sent in. That was their best guy for the job. This is the one that's going to win in court. He said almost nothing. None of the analogs were relevant, and so now we have the plaintiff's attorney coming up who does a much better job.
Good morning. May it please the court. Raymond DiGiuseppe on behalf of appellees, plaintiffs. I had a number of points to raise, just an introduction. It's more of a summary of what we've already argued, so I don't know that I need to put a lot of time into that. As Your Honor pointed out, no need to use time if not necessary. I thought instead of repeating what you already know, our position is that the plain language covers it. There's not a presumptive lawfulness of this law, and if there is, it's easily rebuttable, and there are no historical analogies that would apply. That's all in place. I think jumping to the point that Justice Forrest raised, that it would be absurd in the First Amendment context to imply some kind of rule like this, which says that you can only buy X number, or I'm sorry, no more than one printer press, no more than one pack of paper, no more than one ink cartridge, can't access Facebook more than once a month. We're not going to allow those things to occur any more than once a month on the notion that somehow it's necessary in order to control what you might do, what might happen, dangers that might occur if that is allowed more frequently. Clearly, innovation of technology and the advancement of technology in terms of the dissemination of information and the distribution of information in the informational realm is extraordinary from the time of the founding. And the government isn't accorded greater leniency, power, regulatory strength in going after individuals to curtail their rights simply because they can now potentially cause more harm in these various fora that are available to promote or decimate free speech that is harmful in some way.
Again, keeping with the comparisons between the First Amendment and the Second.
Can I ask
Second
you
Amendment
about
is
the
not a
Ninth
second-class
Circuit's
right.
discussion about ancillary rights? I mean, the Supreme Court hasn't done that, hasn't talked about ancillary rights. We have in a couple of cases. And I think some people question whether our discussion and development of that issue survives the Supreme Court's reasoning in its string of recent cases.
All
What's
right,
your
we're going to
position
go
on
ahead
that?
and stop it there.
I think that's a great end.
Now, I know you guys' time is valuable, so I'm just going to summarize what the plaintiff's attorney said after that point. If you guys want to see the entire thing, I'll put a link to the Ninth Circuit Court of Appeals YouTube video down below, and you guys can watch the rest of it for yourself. But, I mean, basically, it's just the same thing. The plaintiff's attorney just absolutely blows him out of the water. He comes up with facts. He's like, look, there's no place where this would ever be considered constitutional. 10 days, still unconstitutional. You are denying somebody their rights for, an excessive amount of time. There is, no reason to do that. He explains that really this is just a cool-off period for people who the state doesn't even know need to be cooled off. The other judges also point out several other things about, well, maybe I want to go in and I need one thing for this and I need one firearm for that. And so I have, different needs when I walk in and I can't do that. And as a matter of fact, one of the judges, which we're going to touch on here again real quick, one of the judges, the Obama-appointed judge, actually brings up a really good point about the movie studios and why they're exempt from all this, which essentially makes a class of people who don't have to follow this law.
I'm going to take you a little over time, but since I'm in the middle chair, I get to do that. So there's one part of the statute, this may seem like a softball question, but there's one part of the statute in reviewing it that really kind of jumped out to me. And it wasn't in the briefing and it hasn't been discussed today, so maybe I'm missing something. But under 27535 B6, there's this exception for movie studios. And I'm just trying to understand, when we analyze this case, if it was before Bruin, when we were applying like intermediate scrutiny or whatever we were doing,
Right.
to me that would seem very relevant that this statute was bad, because you're telling ordinary people no, but if you're a movie executive or a production manager for a movie company, you can buy as many guns as you want. So under the old regime, this would be very troubling to me. Under the new regime with Bruin and Rahimi, do we apply any level of scrutiny when we see kind of random exceptions like this, or does it not matter because we just do the historical analog?
I think it does undermine the state's position insofar as we get to the point where we're looking at what the justification is, right? I mean, it undermines the notion this is really needed for what they claim it is. It's not needed. As pointed out in our briefing, there's a litany of
Sure.
laws that cover this already. And so I think it does help us in undermining what it's really all about. And secondly, note as well, if I could quickly throw in the point about exceptions, there was a lot of emphasis previously by the state about the private party purchase exception. Well, that's now being erased.
So after watching oral arguments in Nguyen v. Bonta, I just don't see how this ends up surviving. Now, we all know that there is a fairly good chance that this is going to end up being appealed to the en banc panel, right? So essentially, a majority of the Ninth Circuit Court of Appeal judges would overhear this. In other courts, other circuit courts that are a little bit smaller, it would be the entire circuit court. But the Ninth Circuit is so big that they actually don't use all of the judges. Nonetheless, it will probably be appealed there. Now, this case being so strong and having so many judges, if this comes out unanimous, which I think that it might actually, which is very surprising to me, but if this comes out unanimous, there is a chance that the appeal would be denied at the Ninth Circuit level. And so if we get a good order out of this, overturning California's 30-day waiting period, essentially, then that would I mean, that would be it right there. It wouldn't need to go any further. This would just be a win at the en banc level, and that would be it for that for the 1 in 30 rule. The 1 in 30 law would essentially be done. So this may end up, I'm not sure it will, it's the Ninth Circuit, you just never know, but this may end up being a bigger win than I thought it would be. I'm not sure that the Ninth Circuit en banc would actually take it. I mean, there's some pretty strong arguments here, to have that law overturned, and really no strong arguments that I can see whatsoever to keep it up. So anyway, I will keep you guys up to date on this one. I hope that we get the win in it, and I will let you know as soon as we hear anything about it. Now that we've had this, I assume that California is going to appeal immediately, but we'll find out about that soon enough as well. So I want to thank you all very much for watching. I know it's a little bit different of a video than I normally do, but I wanted to share this with you. I want to thank you all very much for watching. Please like, subscribe. You guys have a great day.